One cannot suggest that the speaker must sit at home and sit it out till his motion is heard. There is some check and balance within the system, and you note with.
But Mr. Salve, then what is the sizable number of?
That's not for your lordships. The law
bringing in split by the back door.
No, I'm sorry. I'm not inviting the court to do that. So, my lord, when the governor calls for a vote of confidence, why should a chief minister continue in office even one day if he doesn't command the numbers? I start by saying, my lord, your lordship is being invited to embark on a journey which is entirely political in nature, my lord. It's a journey without a destination. It's swearing in of Eknath Shinde. Now, my lord, what did the governor do wrong? A chief minister has resigned. He has to accept his resignation. Conduct when he is faced with emotion. And my lord, one of the things your lordships have been considering is the problem about whether those observations of the earlier judgment of Nabam Rabia, whether they are to be read as a speaker being denuded of power to act, whether he is being subject to a code of conduct. My lord, one can perhaps put it more on the manner of exercise of power, as I submitted last time.
Yes.
Rather than absence of power, because there are 50 other functions which a speaker has to do. A speaker has administrative jobs. He has to run the assembly. There may be other things going on. Surely, my lord, one cannot suggest that the speaker must sit at home and sit it out till his motion is heard. There is some check and balance within the system, and your lordships have in the statute compilation the Maharashtra assembly rules, and I believe there are similar rules in other assemblies too. Your lordships have Rule 11, which gives the time limit of 15 days. And my lord, my respectful submission is, it may not be really feasible to say in black and white in what circumstances the speaker should or should not act. Normally, a person who's under a significant challenge should not act. If, my lord, a speaker, look at it's now academic, but the reason why we went to court is the speaker did not even give the period which you have to give for a reply under the rules. And it could be that the numbers were such that the speaker may have lost, who's probably lost his position. Because, my lord, one thing I do want to restate, I said this the other day. We know paragraph 3 about split has been deleted. One of the things which did prevail when your lordships upheld this law in Quixote as not being an anti-dissent but anti-defection law is that if there's a sizable number of breakaways, then it is not a defection. Then it is exclusive, because one has to balance the right to dissent with.
But Mr. Salve, then what is the sizable number of?
That's not for your lordships. The law
bringing in split by the back door.
No, I'm sorry. I'm not inviting the court to do that. I'm saying something very different, my lord. In fact, my respectful submission is your lordship has to take it as you find it. There was a provision for a split which has now been deleted.
So therefore, the plain consequences that a split goes away.
I'm sorry, my lord. I'm not saying to the contrary.
Till that it's a 1/3 or a 2/3 or
Is this to be ignored today? That's irrelevant. If you are found to have crossed the line, it doesn't help you to say that the number of people who crossed the line was more than 1/3. But whether that law, whether Kyoto, because Mr. Sibal also said maybe someday Kyoto will have to be relooked, maybe even on this Kyoto will have to be relooked, because has this law crossed the line and become an anti-dissent law, is something your lordship will consider if the law is challenged. Because one thing, my lord, which your lordships would consider, yes, we know there is a problem about political morality, but that problem is on both sides of the fence. It cannot be, once you're in, you lock the barn doors. To say that a person becomes chief minister if his entire legislative party is rebelling against him, you must wait till he goes to the election commission, then they get the party split at the election commission level. And then what happens? I go to the election commission and say, we are the real party. You come and have all your legislative members disqualified because no split now. So you come to the speaker and say, my entire party is rebelled, throw everybody out. I am the sole person, you can't remove me from chief ministership. But this is surely not what the law was meant to be. So all I am saying is, yes, we know there is a problem. And the legislature has tried to address it by bringing in the 10th schedule to the extent it has. But this overstatement saying, because this is so, you must unscrabble everything, you must transfer everything to Supreme Court, a resigned chief minister must be asked by a mandamus to come back and take office, or his accept of his resignation must be set aside. God knows what sort of reliefs have been asked. So, my lord, my respectful submission is, and even as far as the governor is concerned, the solicitor is addressing your lordship. But since one of the issues does arise, is challenge to the governor's order. My lord, one thing which Bomai has laid down and laid down very clearly is that floor tests are not to be in Raj Bhavan, floor tests are to be in the assembly. Head counting is not to be done in Raj Bhavans, because that is the root of a major evil. Whenever there is a question mark on the ability of the chief minister to command confidence of the house, the governor must call for a vote of confidence. The governor must not entertain people in Raj Bhavan and do head counting. Now that's the law your lordships have laid down to prevent politics from entering Raj Bhavan, if at all that is possible. So, my lord, when the governor calls for a vote of confidence, why should a chief minister continue in office even one day if he doesn't command the numbers? So yes, there is a problem of horse trading. But you are also leading a party. If there is a problem within your party, the problem is not only to be resolved in courts. So, my respectful submission is getting into this thicket, is inviting your lordships to depart from established constitutional principles which are judicially manageable. We have judicially manageable standards. Your lordships have said floor tests are the test. Let democracy play out in the floor of the house. That's a lodestar of this law. The governor did nothing wrong in calling for a floor test. Yes. So, my respectful submission is on the 3 steps. As far as the Navam Rabia judgment is concerned, first of all, that question doesn't arise, and it's not a matter which is free from difficulties. But if your lordships are persuaded to get into relooking that judgment, then there has to be some discipline. And that discipline can be brought in by a doctrine which we understand, and that's abuse of power. So, my lord, it's not absence of power, it's the manner of its exercise. And if in the facts of a case you find that there is abuse of power, a speaker has jumped the gun and done something which he shouldn't have, the courts are there to remedy it. So, my lord, that is the submission as far as Navam Rabia is concerned. Now, my lord, one other question which had come up, which I mentioned and your lordships are also saying, can a mandamus issue to the governor to decide But that actually stands answered, because although it had been referred to 5 judges, a later judgment answers it, based on the observations in Rana. But on first principles also, there should be no difficulty. If your lordship sees the Quixote judgment, I start by saying, your lordship is being invited to embark on a journey which is entirely political in nature. It's a journey without a destination. And that journey is to speculate on what would have happened had a trust vote actually happened. Because your lordships have never come to the conclusion, and I dare say your lordships never will, that the pendency of a challenge to somebody is continuing in the house renders that person legally disqualified until he is requalified by dismissal of a disqualification. So till your disqualification is decided, you are entitled to participate and vote. Yes, the system is not powerless, the courts are not powerless. If you find that a trust vote in fact was vitiated by the participation of a large number of people who 3 days later were disqualified, and what has happened is an abuse of the power and abuse of the constitutional provisions, the courts can always intervene. Now, my lord, today, apart from the figures which we have given to your lordships, the admitted position is there were 16 petitions on which notice was issued, and the gap was 58. Now, what would have happened? Forget this 58, my lord. This is also a coalition government. God knows what would have happened when the trust vote, if it had at all taken place. So, my lord, to invite your lordships to assume like a legal fiction that if the trust vote had happened and if these 20 had been left out, or these 32 had been left out, and then the balance would have had a change of heart, or something else would have happened, and then all these votes would have gone, and our coalition partners would have supported, and so would have won the trust vote. It is a journey which your lordships would not embark on. Now, if I am right there, then nothing survives in the first part of this case. The second part of this case is swearing in of Eknath Shinde. Now, what did the governor do wrong? A chief minister has resigned. He has to accept his resignation. Another person comes and says, I represent a party on which elections have, I represent a majority in the house. He goes. He has not won the majority. Now, if somebody says that he has won the majority by abuse of power because disqualification petitions are pending, those are matters yet to be resolved. How many numbers, how many are pending, what has happened to the disqualification? And I do remember a lot before the former Chief Justice, because the tide had turned, as they say. And there were cross-disqualification petitions against those who voted against the present incumbent. And they did also want the speaker to decide those disqualifications. So virtually there was I remember in one of the hearings, the idea was don't aggravate things, let things lie. That's why things have not been decided. Your lordship will direct in whatever reasonable time, the speaker will decide now all pending disqualifications. If somebody is dissatisfied, then you have your remedies under Article 226 if the speaker gets it wrong. That's all that remains in this case now, at this stage, is my respectful submission.